Alrighty, folks, looks like we are live. I'm George with Solo Suit. Very good to see everyone tonight. Looks like the audio visual is working fine. If it's not, just go ahead and let us know in the chat ASAP. I'm here with my friend Dennis. Dennis, can you go ahead and tell us a little bit about yourself?
Yeah, hi, my name is Dennis Charney, and I am an attorney and I work on cases in Idaho, Utah, and Arizona. I've been associated with Solo Suit for just about 5 years now.
Wow, what a time. That's great.
Yeah.
Nice. Dennis is also a firefighting helicopter pilot in his spare time. So that's a fun fact to know about Dennis. Great. We are going to go ahead and talk about what to do when being sued for debt. We have some attorney secrets here from Dennis tonight, so that's what we're going to be talking about. We also reserve about 15 minutes at the end of the webinar for any questions that the audience has. So if you have any questions, just go ahead and put those into the chat now. We'll try our best to get to those. A few people have already put in your questions. That's great. Go ahead and put in a few more questions and go ahead and get that done. If you are being sued for debt, you can go over to solosuit.com and use our debt answer product to respond to the lawsuit. I'll just put a link to that here in the chat so you can use that link and use us to respond to the lawsuit. All right, Dennis, jumping into things. What happens when you get a court summons for debt?
The first thing that happens when you get the court summons for debt is that a clock starts ticking, and it will be a different time period in different states. Some states the clock is 20 days, some states the clock is 45 days, so it depends. So you need to read that summons very, very carefully, because the first step is that you must get an answer filed with the court where the complaint has been filed, because if you don't, then at the expiration of the period that is reflected on the summons, you can, the person who is suing you, or the company that is suing you, usually in cases handled by Solo Suit, can go ahead and ask the court for a default judgment, which will deprive the person being sued of the ability to try and defend the case.
Right. Fantastic. And what can you do if you're being sued for a credit card debt? So let's say you get one of these summons, it's for a credit card debt. What do you do next?
Well, what we do is, utilize the services of a company such as yours, George, which would be to fill out an appropriate answer form. Typically speaking, the answer form, when I answer them for clients on my own, or when I'm advising people who wish to do this type of thing without having to pay the expense of an attorney, I usually ask the client or advise the client to go ahead and file an answer that is kind of mirrors the complaint. In other words, if allegation number 1 says that I am Dennis Charney, I either need to admit or deny, and typically on things like that, you do an admission, and all you typically have to do is to say admit or deny. And then process would be repeated for the remaining allegations in the complaint, where then typically the allegations that really matter, such as that you opened an account and that you defaulted and that the amount that's owed is $12,900, are all things that one would deny to put the case at issue with the court. And then that will grant you the ability to at least to try and negotiate with the company, whether it's a debt collector or an actual credit card company that's suing you.
Fantastic. I think you've kind of gotten this covered already. Another question we have here is, how do I respond to a summons for debt?
Yes, and in addition to filing the answer and getting that handled right away, a strategy then that I often employ in credit card cases, most credit card cases, is to demand arbitration pursuant to the credit card agreement. And that's, I believe that SoloSuit also sells forms to assist customers with respect to that process.
How do you think filing a motion to compel arbitration factors into settlement? Let's say somebody wants to settle this case. Like let's say they agree they owe the debt, but they think it's a bit higher than they should have to pay. Is like filing a motion to compel arbitration going to assist them on the path to settlement, do you think?
I believe so. I believe in most of the cases when I have been defending people alleged to be in default on credit card debt, that the motion to compel arbitration typically gives those clients a significant advantage. The reason is this, is typically speaking, credit card debt that is being pursued on behalf of a debt collector, for example, has been purchased by that debt collector for pennies on the dollar. In other words, if they purchased a debt from Discover Card, as an example, and that debt was $10,000, they might have paid $500 for it. And then that $500 gives them the right to go ahead and try and pursue it. So anything they make above the $500 is profit to them, and Discover Card in the meantime has gone ahead and written off the remaining $9,500 of that debt. So the debt collectors in those types of cases want to spend as little money as possible to try and collect that debt, which is why they hope that when they file suit, they'll get a default judgment and then simply be able to garnish somebody's wages or attach a bank account. If arbitration is demanded pursuant to the credit card agreement, which most credit card agreements do contain an arbitration provision, it is the obligation of the credit card company then to go initiate arbitration against the individual, because the case will be stalled or what we call stayed in court. And then the credit card company is forced into the position of having to initiate arbitration through private arbitration, usually through something called the AAA, or American Arbitration Association. That is a very, very expensive process, and that cost must be borne by the person who is pursuing the matter. And so they're looking at it thinking to themselves, they don't want to throw good money after bad, and it puts them in a position where they are much more willing to compromise what they might otherwise be demanding if they know they're going to have to spend $4,000 more to pursue a debt that's only worth $10,000.
Right. And what about...
You've heard the phrase, throwing good money after bad, and that's really what their thought processes are.
Indeed.
Sorry to cut you off.
What about before a lawsuit? If someone is in collections, they think they might get sued, they've received a letter alleging they owe a debt. Should they send a debt validation letter? Will that assist them on a path to settlement, do you think?
It certainly doesn't hurt. The federal law mandates that any debt collector provide certain documents in response to what we call a debt validation letter. And the debt validation letter is a letter that somebody who is alleged to owe a debt can send to a creditor, which demands essentially proof of the debt. What's the account number? Who is the obligor? Why do you claim that I owe you $7,952? Specify that. And it's typically more of a thorn in their side. Oftentimes they will have it, but it takes them a while to gather up and obtain the documents. And in the meantime, rather than comply with the debt validation letter, they may very well reach out and try to offer a settlement. And that's especially true in those cases where it is a debt collector that has purchased debt, because in the past I've been able to obtain the agreement between the debt collector and the original creditor, and it essentially says, you're buying the debt, we probably won't help you out, we probably won't even validate this debt for you, and so if you kind of hold out, you may actually win by demonstrating that they actually don't have proof that the debt is owed, even though it actually might be.
Okay, we got some questions from the audience here. Got lots of people
Okay.
on tonight, so make sure you get your questions in to the chat. Question from Jack. I requested arbitration and the court refused the request. They said they do not need to give a reason. What can I do now?
The only thing that, well, you could do one of two things. You could ask the court for reconsideration. I don't know what the particular facts are, or if if Jack had submitted a copy of the credit card agreement that showed the arbitration clause. But typically speaking, it's pretty easy to find the statute in any particular state, and they're all differently numbered and slightly differently worded, but they all essentially stand for the same thing. That if an individual demonstrates to the court that there is an arbitration agreement in existence and a party to that agreement insists on arbitration, that the court must stay the case, in other words, pause the case, and order the parties to go to arbitration. If a judge is ignoring that, you can ask the judge for reconsideration, maybe cite the statute if Jack did not know to do that, attach the contract, and then if you still don't have luck with that judge, then you have to go through the appeal process, and that's probably beyond the skill set of a typical person who doesn't appear in court every day. It gets pretty complex.
Right. Is there grounds for a judge ever to reject arbitration if it's in the arbitration agreement?
A late file. Oh, I'm sorry.
Yeah.
A late filed arbitration demand could be grounds, but typically speaking, when I file the answer or advise a client to file an answer, I have them file the demand for arbitration simultaneously, so that there's no allegation of that. The only time you really can't file an arbitration demand is after judgment has been entered, unless the court says otherwise. So there really should not be grounds for courts to do that. And if you look at this from the perspective of the courts, typically they love them. And the reason they love them is because everybody knows and hears the court system is so backed up, so clogged, everything takes forever, and that's because there's so many cases. So when a judge sees a case come through with a demand for arbitration, they're like, woohoo, this is great, one less thing for me to worry about. I'm going to stay this case and send these people somewhere else to go fight their battle, and I don't have to deal with it.
Right. Interesting. Great. We'll jump into some more questions from the listeners. We have one from Sunny. Missed court last week. Pulled my court records this week. It said this in pro per answered dispo as of dismissal August 7th, 2023. Other court ordered dismissal on August 22nd, 2024. Not sure what it means. So one document said in pro per answered dispo as of dismissal. So it's quite the statement.
Without knowing what the nature of the case is and what state or anything, that there's too little information there for me to offer any meaningful response. I'm sorry about that.
Yeah, it sounds like there's maybe like two documents here. Does pro per mean anything to you?
Not in the context that I'm being asked the question.
Right. Dispo might be an abbreviation for
disposition.
Disposition, but
yeah.
What is a disposition in court? There's a deposition.
Well, there's a deposition, which is much different than a disposition. Disposition would be case dismissed, or judgment in favor of the plaintiff, or defendant's motion for summary judgment granted is a case disposition. But a deposition is where the opposing side gets to ask questions of of witnesses.
A disposition is like an order?
It could be, yes.
Well, it sounds like he had another document saying court-ordered dismissal.
Well, if that's the case, then that would be good
Right.
for that person.
Sounds like generally a good thing there, Sonny. All right, moving on to Ravneet. Hi, I have a business loan with BHG Loans Company, and they sued me without warning when I stopped paying. Now I am paying monthly, and they have put the lawsuit on hold. Doesn't sound like she's not necessarily asking a question. Maybe she's just kind of wondering what happens next in this situation.
I don't know, other than if they have worked out an agreement to not pursue the lawsuit while this customer or potential customer is working out payment arrangements, then I would say that's good news. But judges can stay proceedings pending settlement or resolution, and it sounds like that may have been what occurred in this particular case.
Nice. Okay, here she has a follow-up question from Ravneet. So if I stop paying, will I owe the whole loan amount right away, or can I stop paying and negotiate still?
Probably the answer to that question is in the affirmative to both. The lawsuit would probably get reignited, so to speak, by BHG. But if the circumstances changed and this person couldn't make the payments that they're currently making, maybe they'll negotiate again. That they will. Every single creditor out there prefers getting something to nothing, and they definitely prefer settling to fighting. So, to a certain extent, they have an advantage because, typically speaking, they're correct with respect to what they're saying in the court papers. But on the other side of the equation, you have the upper hand as a debtor because you've got something they want, and they want to get it as easy as they can.
Right. Okay, question from Amy. Hey there, just submitted my response to a summons for $250 of medical debt. Should I call the attorney suing? If I want to just pay the debt, will they try to get me for the larger demand amount?
Wait, so she was sued for $250? Is that correct? $250?
She was sued for $250. She responded. Now she's wondering, should she call the lawyer that's suing her? And then she's also asking, like, if I just want to pay the debt, will they try to get me for the larger amount, basically?
Oh, I'm guessing, I'm speculating here, but maybe that they are also asking for court costs and attorney's fees and things along those lines. And maybe she can type in maybe a little bit of follow-up. But it probably would not hurt to reach out to the attorney because settlement negotiations and discussions are not admissible to prove that a person does or does not owe something. So it would never hurt to put out a call and say, look, I can settle this for $125 or $175 or even the $250 if you'll dismiss the lawsuit. And the other thing that they really, really like is lump sum payments as opposed to payments over time. So they're going to be much more inclined to take $250 to settle it in full as opposed to $450 over 10-month payments of $45 apiece.
Right. Another question from Kara. Went to court last week, met with Synchrony's lawyer. He first asked to do I acknowledge the debt? I said I didn't have enough info to acknowledge it or not. He then asked the judge to reschedule and said they'll mail me proof of the debt. What do I do now?
What I would do is wait for the proof of the debt. And by the way, I have to commend her. I think that her answer was brilliant. She didn't say yes, she didn't say no, and that's exactly how to handle those questions, whether they're written or verbal like that. So good for her. I think law school could be in her future. So, but in any event, if if there's already a lawsuit going on, maybe she wants to consider the idea of an arbitration demand. I'm almost certain that Synchrony has an arbitration clause in their agreement, but any of the customers can go to the consumerfinance.gov website, and then they can use that website to search for their particular credit card issuer, and then there's a database of all credit card agreements that's required by law to be there. So she could go to that website, she could find whether or not there's an arbitration clause in her credit card agreement, file an arbitration demand, and she'll stop those guys in their tracks.
Nice. All right, Kara, if you need help studying for the LSAT, let us know. We got a question from David. Sued by Discover. They were a no-show in court. Default judgments, sounds like he was a no-show. So he was sued by Discover. David was a no-show in court. There was a default judgment. Can I vacate the judgment? There's a lien on my home now. I'm willing to negotiate. How do I proceed?
That's going to require, at that point, probably consultation with an attorney in that customer's state. In general, a judgment that is recorded in the county in which you reside will operate as a lien on property. There's going to be lots of exceptions across the 50 states, but that's a very broad general statement. But if the case has already gone to judgment and it's to the point where there's a lien, there may not even be time remaining under the rules of civil procedure to do what's known as file a motion to vacate the default judgment, which is usually something that a court will grant if an individual can demonstrate that they had excusable neglect. And I don't know which state this person is in or whatever, but he's probably beyond the help of a self-help website such as yours.
Yeah, you got lots of hearts and 100% on that answer there from the chat, Dennis. So there you go. Yep. Yeah, and for those listening, a lien is basically a hold on the finances of your house, right? So if you have a lien on your home and you sell your house, the money goes first to pay off the debt that has a lien on your home.
That is true.
Yep. Great. A question or an update from Holly. I'm being sued for an old medical debt for around $2,700. The court date is in December. The lawyers are saying it's the hospital, but I called and they don't have the bills for that year. The bill is from 2022. So she's being sued for $2,700. The hospital doesn't have a record of her bill.
Okay. She's entitled, if she wanted to look up, the discovery rules in her particular state, she could make a request for what we call discovery, and all 50 states authorize parties to a lawsuit to send discovery requests to each other. Usually, because there is some uniformity, usually it's Rule 16 in the civil rules. At least it is in all the states that I practice in. And then she could demand all the documents that the creditor is relying on in support of trying to prove the debt. And she can also demand the names of all the witnesses who are going to testify and things along those lines. And if they can't prove their case, she goes to court and lets them try to prove their case and sees where it goes. But it does get a bit more complicated with the rules of evidence and how they can get documents into the court record and things like that. And for a $2,700 debt, it's certainly not going to be worth paying an attorney. So it's as opposed to if it was a $27,000 debt, and so she would probably need to brush up or maybe consult with an attorney for an hour or so to prepare herself for court. Would be the advice I would give.
Great. Amy, a question from her, is telling the collector to prove it, or in other words, denying every complaint in the summons or every paragraph in the complaint. Is that the best way to respond to a summons and complaint?
Typically, yes. If you absolutely cannot admit it, or if it's a fact that is required to be proved, then the complaint, I typically advise my clients to go ahead and just deny it. The easiest ones to admit are what your name is and that you currently reside in such and such county in California or wherever that might be. You can admit stuff such as that. But for facts that are genuinely in dispute, I typically deny those and make them prove them.
Is denying them, is that better than denying for lack of knowledge?
Substantively, the words might sound different, but procedurally, it's the same. It still winds up being a denial. It's like standing silent in criminal court. If the judge asks guilty or not guilty, and you say I stand silent, the judge says not guilty. So it's sort of the same thing. Interesting.
And how do you think about this part? Is denying, is that the same as saying it's not true?
No. It's basically just saying that an individual doesn't have knowledge one way or the other, and they're entitled to deny until such time as it can be proved.
Right. And so, like, perjury doesn't apply here, right? It's not like
no,
you're not on the line for perjury here.
No.
Right. It's just a denial is different from saying it's not true. It's just saying that you deny it and that you essentially like the collector or the whoever is on the other side to prove it.
Prove it up.
Yep, there we go. So that's a crucial point here, folks. All right, we've got time for one last question. If we didn't get to your question, there's a ton of questions in here. If we didn't get to it, hopefully Hannah, she's with Team Solo Suit, was able to get to it in the chat. So you might want to look for your answer here in the chat from Hannah. We're going to skip down to one of the more recent questions. A question from Sylvester. Can Social Security be garnished for senior citizens after a default judgment?
I would say typically the answer to that question would be no, but every state is going to have a different way for an individual to be able to object to such a garnishment and to demonstrate that the proceeds are disability benefits or retirement benefits that are not subject to garnishment. So it's going to be a state-by-state question, but generally speaking, the answer would be no.
Okay. There we go, Sylvester. So if you're getting that SSI, you're most likely really protected, but you'll still want to do what you need to protect it. Alrighty? Yep. All right, folks. Thanks for showing up tonight. Very glad to see you all. We had a lot of people here. Happens that, if you're being sued for debt this week in the U.S., you are not alone. There are probably going to be around 500,000 to 1 million people sued for debt in the U.S. this month. So you aren't alone. We are here with Solo Suit to help you out. Dennis, thanks so much for coming on the show. Everybody,
you're welcome.
Take care.